The Committee on Environment, Land, Agriculture, and Procurement Reform calls this public hearing to order. It is now 3:08 p.m. on Thursday, October 18, 2018. Present with me today is, to my right, Acting Speaker Therese Terlahi. To her right, Senator Mary Torres. And to her right is, far right, is Senator Jim Espaldon. To my left is Senator Frank Agustin, and to his left is Senator Joe S. San Agustin. Thank you for joining me today. The purpose of this public hearing is to receive testimony from the Chamorro Land Trust Commission on Bill number 356-34 COR, introduced by myself. It is an act to validate the Chamorro Land Trust Commission decisions relative to residential and agricultural leases, and to authorize and ratify leases issued from switched application date and time. Notice of this afternoon's public hearing was provided to senators, stakeholders, and local media on October 11, 2018, and October 16, 2018, thus meeting the requirements of the Open Government Law. The committee will continue to receive testimony until 4 p.m. on Thursday, October 25, 2018. Please address testimonies to Senator Thomas Seata, Chairperson, Committee on Land, and can be dropped to the mailboxes here at the legislature or email to office@senatoratta.org. So we'll go ahead and we'll begin with the testimony. And Madam Chair, if you want to introduce who are with you at the table, and then go ahead and give your opening remarks.
Hafide Toru Hamzugwa Husipika Farron, Chairwoman of the Chamorro Land Trust Commission. I have with me here today Vice Chairman Mr. Joseph Cruz, Commissioner Tenamanda Santos, Administrative Director Michael Borja, Commissioner Austin Duenas, and Commissioner Chantel Teixeira. Thank you all for being here, and thank you, Senator Atta, for introducing Bill 356. 2.5 years ago, I stood up and volunteered to serve as a commissioner for the Chamorro Land Trust. When I made that decision, and today, my heart and mind are committed to serving the trust and all of our beneficiaries to the best of my abilities. Last I appeared before you was in May of this year at our public oversight hearings. Since then, these last 5 months have been extremely challenging in my role as chairwoman of the Chamorro Land Trust. I can share with you that it has definitely been the most difficult part of my life these days, which is no easy feat considering I'm a mother of 3, own 3 restaurants, and am working to open a 4th restaurant in the next month. Though the catalyst for these trying times at the CLTC was the Barrigada Heights controversy, I believe that everything has happened for a reason, and that reason is simply to fix the trust for all of our beneficiaries. The awarding of residential and agricultural leases to our applicants has, in my time of service, occurred solely at the administrative level. The Commission, in my short time, did not have in-depth knowledge or involvement into that fundamental function of the trust. However, since the Barrigada Heights controversy, thanks to the questions and guidance from this legislative body and the diligent work by the director and staff of the trust, the cloud of unknowns has lifted. Today, the Commission stands in a position where we know all of our leases, our waiting lists, and our current processes, and we have developed a comprehensive strategy to fix the trust. The bill we will be discussing today is just the first step toward that comprehensive solution. Before I go into the Commission's testimony, I would like to remind us all about the Chamorro Land Trust. I believe that the Chamorro Land Trust was created to heal the wounds of those islanders whose land was taken by our island's colonizers. The trust was meant to heal these wounds by returning those islanders and their descendants back to land that was once lived on and cultivated before its taking. Because of the way the trust has been administered over the last 23 years, There have been newer, fresher wounds experienced by these same islanders and their descendants. Despite this fact, I do not believe that we nor the administration are the real threat to the trust. The real threat is the lawsuit from the Department of Justice. We are at a critical moment in our history where we must come together to work towards fair and practical solutions so we can get the trust working in the way it was intended, to heal our wounds and use the trust to lift our beneficiaries up for the betterment of the entire island. I am humbled that I have had the privilege of serving on this commission during this juncture, and I am committed to working with you all to make this a reality. Now I will present testimony on behalf of the Commission of the Chamorro Land Trust. A copy has been provided to you, Senators. Copies will be made available to the public here at this meeting and will also be available on our Chamorro Land Trust website.
They're making copies right now, so we'll have it out shortly.
Do you have copies?
They're making copies now.
Okay. Shall we?
Go ahead and proceed.
Shall I? Okay. Sorry, I guess we emailed it to you, but was not received yet. Okay, so this is a letter dated October 18th, 2008, addressed to Senator Thomas C. Atta of the 34th Legislature, Chairman of the Committee on Environment, Land, Agriculture, and Procurement Reform. The subject of our testimony, Bill number 356-34, an act to validate Chamorro Land Trust Commission decisions relative to residential and agricultural leases, and to authorize and ratify leases issued from switched application date and time. Buenas Danhofade. The Chamorro Land Trust Commission hereby submits testimony to the 34th Guam Legislature in support of Bill number 356-34. CLTC Resolution 2018-10 with exhibits has been submitted by the Commission. In conjunction with this resolution, the Commission would like to provide the Legislature with further information about the Commission's review and findings that led to the creation and approval of Resolution 2018-10, and to provide the Legislature with the future actions the Commission plans to take in order to provide a comprehensive solution to the remaining issues facing the Trust. In the 5 months since the CLTC public oversight hearings in May, the Commission has focused their review on all Chamorro Land Trust residential and agricultural leases, the CLT policies and administration, and how the Commission may address and correct the findings from the Attorney General's May 11th opinion. This opinion included the findings that any lease without Commission approval is considered voidable, and any lease that is held by an applicant who switched places with another applicant in their lifetime is null and void. After this extensive review, the Commission identified 3 internal practices that current and past CLT administrations followed. The Commission has found that these practices contributed to the various issues at the Chamorro Land Trust. 1. Residential and agricultural leasing is administered and approved at the department level, and leases are not presented to the Commission for review or approval. Leases are signed by the Administrative Director and, in most cases, the Governor of Guam. These leases, of which there are 2,877, were categorized as voidable leases. 2. Switches between applicants in their lifetimes has been allowed since 1997. These switches were among qualified applicants who are close family members. Reasons for the switches include to prevent homelessness. The switching applicant needs the property more. The applicant eligible for a lease does not have the means to use the property immediately, but their family member does. These leases, of which there are 102, are categorized as null and void leases. 3. Any applicant who is on the 1995 waiting list or is derived from a 1995 applicant is eligible for a lease. Up until the Barrigada Heights controversy and the Attorney General's opinion, the prevailing environment at the Chamorro Land Trust was generally positive. For example, Recent years at the CLT saw a record number of leases issued to those strictly from the 1995 waiting list, those who were considered pre-occupiers or held land use permits and are grandfathered into the CLT program, or those whose leases were transferred to them in accordance with the law. This was in contrast to prior years of this administration, when leases were awarded to applicants who applied after 1995 and are not documented as pre-occupiers or land use permit holders. The current Commission's role in the CLT was focused on clarifying various internal procedures and certain lease issues that hadn't been addressed or resolved for years. Further, this administration has taken immense strides to rectify an immense volume of a variety of administrative and procedural errors of leases given out in the past. Over the last 23 years, however, it is clear that the Commission has not exercised its full role and authority in administering the Chamorro Land Trust. The Commission has had trouble meeting quorum for their regular monthly meetings, which commissioners get paid $50 to attend. Some years, the Commission only had quorum for 5 or 6 meetings. It is this instability and lack of consistent Commission leadership that this Commission believes many of the fundamental duties and approvals that should be held by the Commission had shifted from the Commission to the administration level. The CLT Administrative Director during those years had to shoulder much of the decision-making just to allow the program to continue. Once a Commission was working and meeting again, that authority was not transferred back to the Commission. The Commission recognizes now that the CLT has been operating outside of the original intent of the law, and it must be fixed. The first action the Commission took, and is as described in Chamorro Land Trust Press Release 2018-1, is that all approvals and decisions will be made by the Commission until such time the internal practices and procedures are documented and set in accordance with the law, and where the law may allow, certain Commission's authority may be delegated to the Administrative Director. The remaining issues to be resolved then are the findings from the Attorney General's opinion. First, the Commission realized that the issues revealed at Barragata Heights regarding those skipped and those who hold leases were merely a subset of the issues found with other leases around the island and how those leases relate to the waiting lists. Therefore, the Commission decided they could not cherry-pick those Barragata Heights leases and treat them any differently than the rest of the leases for the program. Thus, whatever decisions made must be applied to all Chamorro Land Trust leases. The issue of family members switching their application dates and times and the leases that arose from those switches were reviewed extensively. The Commission found that the Chamorro Land Trust Administration allowed these switches to occur through a documented review process, which included approval from a Chamorro Land Trust administrator, or in some cases, approval was given by the Commission at the time. The Commission considered the options of voiding some or all of these leases, some of which have homes or farms on them and some sitting vacant. However, to draw the line and make distinction between any of these leases would treat leaseholders unfairly. Every one of them was told that their switch was allowed and approved. The Commission also realized that if a lease was voided, the lease would revert back to the original applicant, which would not materially improve the status of applicants still on the waiting list. The Commission also recognized that with the passage of time for original 1995 applicants, the passing of application rights to a family member is consistent with the common practices of our island community. And in recognition that the Commission and CLT administration was at fault for allowing the switches and awarding the leases now categorized as null and void, the Commission decided that the practical course of action would be to ratify them and amend the rules to allow this practice in the future. The Attorney General, however, has stated that the Commission has no authority to ratify those leases. The passage of Bill 356-34 will accomplish this. The Commission then focused on the issue of applicants who have been skipped. The Commission reviewed the 1995 waiting list of 4,706 applicants and current lease lists to see if some line could be drawn to determine where the skipping of applicants first occurred. The first leases issued in 1997 revealed that 1. Applicants among those leaseholders were skipped and still don't have leases. And 2. Leases were issued to priorities 1 and 2. Further review of the lease lists and waiting lists revealed that applicants who applied in 1996 or later have leases, which means that everyone who applied in 1995 and does not have a lease has essentially been skipped. The Commission also found that in 2009, the Commission made a good faith effort to contact and award leases to those on the 1995 waiting list who had been skipped. Many of those skipped individuals remain on our list and have been uncontactable since then. The internal practice to award leases to anyone who applied in 1995 was an attempt by the administration to allow leasing to continue for those 1995 applicants who come forward and contact the trust. However, understanding that there are applicants who have been skipped, the Commission considered conducting an investigation into the 1995 waiting list to determine if, among the list, applicants were intentionally skipped for the benefit of another. This investigation could happen, however, with the limited staffing and resources, it would take an extremely long time to reach firm conclusions. In that time, those still waiting for leases would have to wait even longer because leases would not be issued until the conclusion of the investigation. If the investigation were to take its course and the findings showed that certain applicants were intentionally skipped, what would the remedy be? Would the remedy be to take away leases from certain other applicants and award them to those applicants who were skipped? Should the Commission decide to take away or void any lease, then the Commission would be required to provide the leaseholder a hearing, and if the lease is then voided, any improvements to the property must be paid for by the Commission. This could potentially bankrupt the trust. The Commission also took into consideration the fact that leaseholders may currently reside or farm the property, and to void their lease would render them homeless. The Commission then had to reconsider its mission, which is to act exclusively in the interest of the beneficiaries of the trust. Then, to hold current leaseholders at fault for the skipping of applicants without leases would be unfair. Those current leaseholders were each told at the time their lease was awarded that it was their turn to receive a lease. It was not the responsibility of those individuals to question if anyone ahead of them in line was skipped. Thus, the Commission reached the decision that the practical way to address the lease issues was to ratify those 2,877 leases categorized as voidable and move forward to award leases to those individuals that have been skipped. The Commission has requested that the legislature validate the ratification of those leases. Passage of Bill 356-34 would accomplish this. These solutions to make our leases whole again through ratification, however, do not address the serious issue that 4,706 applicants from 1995 are still waiting for a lease. However, before we can reach those applicants and begin issuing out leases again, the Commission has recognized that we must first improve transparency of the administration of the Chamorro Land Trust. To accomplish this, the Commission has recognized the need to improve and make clear the process for lease awards. The process, as prescribed by the Paul Bordalio Rules and Regulations for CLTC residential and agricultural leases, enacted as Public Law 23-38, as currently written, does not speak to a clear and implementable process, as evidenced by the first round of leases since 1997 and the good faith effort put forth in 2009. Various statutes are ambiguous or impossible to implement due to lack of funding. Therefore, the next step the Commission will be taking is to recommend amendments to Public Law 23-38 and the Tomorrow Land Trust Act. Tomorrow Land Trust Commission Resolution 2018-09 has been approved today by the Commission and is submitted to the Legislature today. These recommended amendments will make the laws clear, practical, feasible, and provide a blueprint for the transparent rules and processes that the CLT can implement. Through submittal of Resolution 2018-09 today, the Commission is hopeful that the Legislature will introduce a bill for amendments to the laws and that further discussion and input from our beneficiaries and the Legislature on the proposed changes to the law may occur. The Commission believes that the laws must be amended before any leasing activities may recommence. The Commission has also recognized that a full-time administrative director, independent from the Director of Land Management, is necessary for the administration of the Tomorrow Land Trust. The Commission will also be requesting from the Legislature for supplemental funding from the Tomorrow Land Trust Operations Fund. The Commission aims to hire this administrative director to begin work on January 1st, 2019. The Commission is concurrently working on improving the financial management of the trust, including ensuring Tomorrow Land Trust funds are spent responsibly on operations and in the best interest of our beneficiaries. This includes exploring ways Tomorrow Land Trust funds can survey and provide access and utility infrastructure to Tomorrow Land Trust properties. The Commission looks forward to working with the Office for Public Accountability and other agencies to accomplish this. Enforcement and compliance by the Tomorrow Land Trust must also be improved to ensure proper management of the Tomorrow Land Trust properties. The Commission is confident that the above decisions, actions, and plans for improvement are the comprehensive solution to the myriad of issues that have plagued the Tomorrow Land Trust program since the beginning. These fixes are not going to happen overnight. It took 23 years to get to where we are today. But the Commission is hopeful that there can be the necessary will from our legislators, transparency from the Commission, and input from our beneficiaries to achieve success for the Tomorrow Land Trust. The Commission must point out that despite the issues we are faced with today, there are 2,979 Tomorrow Land Trust beneficiaries who currently have leases for properties they otherwise would not have. Those families live or farm the land that generations before them once lived or farmed, and we as a community cannot forget the importance of this program to our island. The passage of Bill 356-34 and the subsequent bills to carry out the Commission's remaining action items are imperative to those 2,979 families and the families still on the Tomorrow Land Trust waiting list. We thank you for the opportunity to provide this testimony.
Thank you, Ms. Farron. Do any of the other commissioners want to make a statement? None? Okay. I'm going to go ahead then and at this time open it up for questions from the panel. I'm sure there are a lot of questions, and so that everybody has a chance to get their questions in, I would allow that one question be asked per round, and then we just keep going around until all the questions are asked. And I'll go ahead and I'll ask the first question. One is, can you explain how the first come, first serve rule and the prioritization, depending on who has land or not, how those two work hand in hand?
I think they might be contradictory, because if you're first come, first serve, you're going down a list like this, but then when you introduce the priority 1, 2, and 3, you're not able to do first come, first serve, because if we have a priority 2, then they would be skipped for priority 1.
Okay. So my understanding and my asking around is that the way that those two rules work is that all the 1995 priority 1 and the 1995 applicants are basically broken down into 3 groups: priority 1, 2, and 3. And then that is followed with the 1996 applicants, priority 1, 2, and 3. And that I believe maybe, and it's is it possible that the commission has went through the 1995 priority 1 list and then went to the 1996 priority 1 list and kept going down until you finish all the priority 1 applicants, then went back up to 1995 priority 2 and started. Can somebody comment on if that is the practice?
In the earlier years of the issuance of those leases, you know, I'm not aware, and I didn't appear in the minutes of the meetings that may have been what the practice was, but there is such a significant number of applicants in the December 1995 list that it would beg them to go beyond that to find qualified applicants in the priority 1 listing. And because there are still some priority 1 applicants in the 1995 listing that had not been contacted in any way that the records show. There's a number of them that have been, but weren't issued leases, but there's also still some that have not been contacted for whatever reason, we're not sure.
So then that part of the law then, that leases will be issued out according to priority, first come, first served basis, but then there's the prioritization. The priorities aspect of it was not necessarily always followed. Is that what you're saying?
Most likely. Now, the way that the application was originally designed, and is still pretty much is the same way, is there's a question on that application from the onset, you know, do you own land? And that's all it asked. And it's not until they receive an interview that they may be asked, now, is your property, what size is that property? And where is it? So it's not, you know, and it's anywhere. So, you know, we don't have the ability to check to know if people own land off of the island, nor at the time I don't think people were checking the tax rolls to see if people truly did own land but just weren't reporting it. They went on the word of what the applicant said, either at their interview or on the application itself.
Okay, thank you. Speaker Delay.
Sorry,
sorry.
if I may, the commission did do a review of the master database that shows the listing of all applicants. And in 1997, when the first leases were given out, you would presume that because of the rules and regs, they would follow first come, first serve, give leases to priority 1 first. Within the 1997 leases we looked at, there were priority 2 applicants who did receive leases.
So
That was what happened in 1997. So it seems like back then the commission at that time was not applying it in the sense that you described earlier in your question.
Okay, all right. Speaker Delay. Okay, Senator Ruggan.
Thank you very much, Mr. Chairman, and thank you folks for joining us this afternoon on this piece of legislation. You know, I was following your presentation, and let me just read a couple of excerpts from your written presentation. It says, in recognition that the Commission and Chamorro Land Trust Administration was at fault for allowing the switches and awarding the leases, now categorized as null and void, and then it goes on, the AG stated the Commission had no authority to ratify those leases. Another excerpt in the next paragraph says, lists for further review of the lease list and waiting list revealed that applicants who applied in 1996 or later have leases, which means that everyone who applied in 1995 and does not have a lease has essentially been skipped. And then it reads on to state, if the investigation were to take its course and the findings showed that certain applicants were intentionally skipped, what would be the remedy? And then finally, on this particular one question that I have, one of your paragraphs reads, then to hold current leaseholders at fault for the skipping of applicants without leases would be unfair. Those current leaseholders were each told at the time their lease was awarded that it was their turn to receive a lease. It was not the responsibility of those individuals to question if anyone ahead of them in line was skipped. And that statement is absolutely correct. The families and the individuals who were given leases, they don't have a responsibility to inquire whether they're the next person on that list. So the remedy with regards has to be acquired or reached in this whole situation for the individuals and the families that have leases. But I just read from your testimony 3 or 4 direct statements and assertions that says Chamorro Land Trust staff and executive director, this goes back 23 years, mind you, we're not following the law. At the core of this, they were not following the law. And you know what that tells me? That's really at the core of government corruption. It really is, because there's been no remedy or discipline or termination of staff members and executive directors that have contributed to this whole issue where we're at. So how can, at least from my perspective, how can you come to this body and ask us to clean up your mess? And this is a general statement to the commission and to the Chamorro Land Trust staff who have been there for many, many years. If we're not expected as government stewards to follow the law, especially as it applies to a very important issue, such as this, helping families acquire properties, build their own homes, and be self-sustaining, then how do we expect others who are not in the government system and others in this community to follow the law when people who are being paid to do their job are not following the law? So my question, one question is, and let me preface it with this, because there was a statement that was released, Mr. Chairman, about a couple weeks ago, recognizing that the executive director has done a good job, a stellar job. How can that statement actually be released to the public, knowing full well that that executive director was responsible for overseeing this program, and then we recognize that the laws were not being followed? So my question is, has there been any discipline? I understand about the training, because yes, I was following that the staff were trained and provided updates and information of acknowledging the law and the provisions and the rules and regulations. I understand about the training, that's necessary. But in any organization that does not follow the law, we're going to disregard everything that you've done in the past. We're just going to train you. We're going to educate you so that you can make things better in the future. Well, guess what? That's not a remedy. The people of Guam expect this government to be responsible. So if these individuals intentionally skipped 4,706 applicants in 1995 to give out other leases, if these individuals were not following the law that is attached to this piece of legislation, the Public Auditor rules and regulations, If these individuals for the last 23 years in trying to distribute property were not following any guidelines, then they have no business implementing this program. This is where our people are saying it's got to stop. So my question is, what remedy has the commission taken with regards to individuals who have been there for an extended period of time, whether they're staff members or whether they're executive directors, and have not been following the law? That's my question. Thank you, Mr. Chairman.
Thank you very much, Senator. Please respond.
Sure. Yes, we admit over the last 23 years the law has not been followed to a T. I cannot speak for the decisions made prior to this commission, but this commission's review has found...
I'm sorry, Ms. Farron, don't say that the commission members have not been following it to a T, because 4,706 applicants have been skipped.
Okay, Senator, let her respond, please.
Thank you.
Please proceed.
So, the commission's review over the last 5 months has found that the law has not been followed, but if you track it back all the way to when the Tomorrowland Trust was implemented, the laws back then and today have not changed, and as they are today and as they were back then, they were not implementable. And I believe that over the last 23 years, the administration had done their best to provide internal practices and policies that allowed the leasing to continue. And it is today that we're saying we realize it's broken and we want to reach those 4,706. This bill that we're talking about today would ratify all of the leases, but it's just one part of what the commission is pursuing to fix it. The next is to go back to the law and amend it so it can be implemented.
But with the same staff, the same leadership, training, and then moving forward, when they were the direct contributors to this program not being properly implemented in the last 23 years.
Okay, thank you, Senator. Senator Talai? Senator, go ahead.
I would like to ask, where did I put here? Okay, in part of your testimony, you stated that you ask, if the investigation were to take its course and the findings showed that certain applicants were intentionally skipped, what would the remedy be? And then you ask another question. Would the remedy be to take away leases from certain other applicants and award them to those applicants who were skipped? Should the commission decide to take away or void any lease, then the commission would be required to provide the leaseholder a hearing, and if the lease is then voided, any improvements to the property must be paid for by the commission. So I'm looking at these questions about remedy, and I guess I want to know, did you get advice about remedies from the Attorney General? I was reading her letter, and I see that she recommended a hearing be held for these people.
This is just point of information, Madam Speaker. Those remedies are in the law, are in the Tomorrowland Trust law. To provide a hearing,
The hearing.
to pay for any improvements that have been made on the land. Those are in existing law right now.
For when applicants are skipped? I guess.
No, if the commission is going to pull a lease, and let's say that individual has built a house on it, then the commission is required to pay for the improvements that have been made on that property, and the law also requires that a hearing be provided to that individual.
All right, so I guess under what conditions then under the current law is the commission allowed to pull a lease?
Whenever the terms of the lease agreement are violated for any kind of activities, there was one, the last one really that was done was an individual who was caught actually stealing truckloads of soil. And we terminated his lease. It's still pending a hearing because we did not get our hearing officer approved until just a few months ago.
All right, so I guess I just want to get this confirmed then. These questions, have they been answered to your satisfaction by the Attorney General? The questions about remedy and this part about that you would be required to pay the leaseholder if there are improvements. Is that been?
So we have legal counsel who is a representative from the Attorney General's office present at each of our meetings. And yes, he was.
So that's their advice?
Yes.
Okay, so then I wanted to know how many of these that we're talking about have improvements? So in this category, those who have been skipped. Those who skipped, how many of them have improvements versus non-improvement?
Well, those that were skipped wouldn't have a lease, but those who have a lease, the information they provided shows the assessed value of the land and the assessed value of the building that's on that property.
All right, so would you say okay, give me a second. Do you think it's a majority of these that have values?
Yes.
I'm only seeing one page.
Well, that's one. There's 2 pages to each list. So that's one list, and that's followed by the next list. And it gives more history, the trail.
Senator, regarding that question.
Yes.
I did an assessment on the listing that we got.
Okay.
On the total number of applicants that were issued a lease through SKIP. I did an assessment on the improvement and the land value based on the taxation. The total land value of 230 applicants rounds up to 15 million.
Land value with improvements.
The building value.
Huh?
Building value instead
Building.
of, yeah.
Okay. All right. Thank you very much.
Thank you. Senator San Agustin?
Thank you, Mr. Chairman. Madam Chair, you know, this whole event is all a result of Barragata Heights event, okay? How many lots are those and what action has the commission taken? Because I'm reading the law, the bill, and all your testimonies talking about something that happened several months before the Barragata incident. I'm very curious, how many lots are those in Barragata Heights? And what has the commission done to null and void the leases? So that maybe we can talk about the other issues of the non-compliance of the law. I'm just curious about what's going on with the Barragata site.
The commission found that the issues at Barragata Heights were merely a subset of the issues for the entire land trust program. And so in addressing the issues, the commission decided that we could not cherry pick those Barragata Heights leases. Instead, we had to broaden our view to the entire program.
Ma'am, I'm almost sure the $15 million that Joe mentioned has nothing to do with Barragata Heights because there's no building yet. So there's no money there. I'm almost sure it doesn't impact revenue and tax when we talk about after you have the lease for 7 years, you start paying real property tax. So I'm just trying to understand why couldn't the commission go in there and say, for Barragata Heights, you're null and void. Let's go over this one more time because why? You have determined that the law wasn't being complied with. That should have been an easy one. It's bad enough already that, you know, it's on the news, doing clearing, without a permit, a whole bunch of stuff. That should have been something. I believe the commission should have just stopped and done what they need to do. Then we can talk about the other leases and try to fix. But to add them all together, there's no cherry picking there. There's nobody moved into those properties yet. And if they did, then the commission is trying to add them to the rest of the folks. And I think that's unfair. Okay, so I honestly believe the commission should take a look at what you got today and what caused the problem, then we can consider the others. Because I couldn't support adding everybody that's 10 years, 20 years ago. Because I know my name is on that list in 1995 when I signed up. I still don't have one. And that's not an issue with me. Got tired of waiting, I went and bought my own property. But I'm just concerned is if you got a problem with something yesterday, you should fix it. Last month, we can work on and figure out how to resolve the issues of the null and void and come to some reasonable agreement so that the people of Guam that have their homes there, have their plantation, and are paying taxes, be seriously given the approval to continue. That I can consider. But something that's hasn't moved, you guys should have taken care of it. Thank you.
Thank you very much, Senator. Senator Torres? Senator Spaldon?
Thank you, Mr. Chairman. I guess since we can only ask one or two questions, or a question with maybe a related question, maybe I'll start with something that's very basic to me. Altogether, there are how many applicants left who have not been given any land?
For the entire program, how many applicants don't have leases? Sorry, the 4,706 number is just 1995 applicants.
Just 1995.
Yeah, so we have applicants that have applied up to probably tomorrow. Let me get that number for you.
Is there kind of like a ballpark figure? We talking 10,000? We talking 15,000? We talking more?
You're talking about 8,000.
About 8,000 who are on the waiting list all the way up to today who have not received any property, right? And I guess the question behind that is that going forward, the ability for a chamorro, as defined in the Act, to apply for a piece of property continues on into the future. Is that a fair statement, or is there a cutoff? In other words, say for example, somebody wants to apply today who has not applied since 1995, right? Are they eligible to apply?
Yes.
So is it a fair statement then to say that we're kind of in a problem situation because we have a finite amount of land in which we can actually dole out to applicants, and yet we have conceivably an indefinite amount of people who actually are qualified to be able to apply? Is that a fair statement? So the real question that I'm trying to get to is, knowing full well we have 8,000, 9,000 applicants right now. Well, let me ask one more question before I get to my real question. Do you know how many acres the Chamorro Land Trust controls or has to be able to dole out?
I don't have that number off the top of my head, sir.
Ballpark? None? Well, here's the point. Let me just get to the point then. In some of these applications, and I just now saw your submittal of resolution, what is it, 1809, 2018-09, and you changed some of the terms, and one of them is, I believe it has to do with the half-acre lots, right? I guess if there's a piece of property that doesn't have any infrastructure in, the minimum size that you're recommending, before it was unclear, but before it was, or at least existing law right now, is 10,000 square feet, quarter acre, let's call it, right? And you're asking to increase that size to a half acre, which seems appropriate considering that our laws right now under an agricultural zone, right, requires that you have at least a half acre so you can put in the septic tank leaching field to be able to accommodate homes. So far, so good, right? And correct me, just step in if I'm wrong, okay? Because I don't want to go down a road and I'm misstating fact. I guess one of the problems that I've kind of had to deal with over time, and now really paying attention to this whole issue, is that I know that we have been giving out lots much larger than a half acre. And the dilemma I find that we have is that if we're giving away larger pieces of property and know full well that we have a very limited amount of property, then how can you give out land larger than what it takes to sustain the building of a home and a residential area? And I know that there are some applicants who have gotten way more than a half acre or 1 acre. They've gotten 2, 3, 4, and some of the agricultural lots, much more acreage. And I guess the problem I have is I'm not sure there's ever been a follow-up to find out whether anybody was really in compliance with the law once the leases were given out. And I understand your statement, that you definitely need manpower, you need the funding, you need the ability to go out and enforce. But for us to come in here and ratify everything without having any checks done on the leases that have already been put out, because I understand that some leases actually have been put out to some applicants, and those applicants don't even live here. And they hold on to some agricultural leases, and we're talking acreage. We're not talking half acre or 10,000 square feet. We're talking a substantial piece of land which could actually be split and doled out to those in line. And yet within this resolution that you presented, there is no addressing of that issue. In fact, I think your wording is a little is subject to perhaps some other problems, because you don't say less than an acre. I mean, there's some verbiage that really opens it up. And I'm just saying, I know it's a draft, it's a recommendation, but the issue, though, I'm trying to point out, is that you're right. There have been problems all along the way. And if you're going to address going forward, if you're asking us to ratify right now, I think one of the senators, my colleagues, is right. Let's correct some of the problems that are in front of us right here, right now, but also take a look at the whole concept. There's a very limited amount of land, and yet the list of applicants is not limited. And so how do we handle that? How do we handle that intelligently and wisely, right? And how do we follow up on some of those pieces who have not conformed to the law once they were given their leases and have done nothing with it? And the other thing that I noticed, that I do know, is the requirement of an agricultural tract. All it takes is plant a couple of trees and you're good to go. Is that really agriculture? Maybe we need to relook at that as well.
If you look at the resolution that we submitted, 2018-10,
okay,
those were the null and void leases. And you'll see that there's a staff report with photographs for all of them. And so in the case of agricultural leases, the law was specific not on just a couple of trees, but on a specific number of trees per acre per year.
Per year for 5 years.
That they had to keep planting.
That's correct.
So, those are the kinds of things
that it will show as well. And I believe it was 6 acres, 6 trees per year per acre, or something like that. I think it was 6 or 12 trees. And again, it didn't define what kind of trees. It didn't even say fruiting trees or edible, something that has anything edible, or flowering that we could actually sell back.
But the law did specify at its onset that the agricultural lease could go up to 20 acres. And in the early days, there were a number of leases issued out in sizes up to 20 acres. We have not been doing that for a number of years. And
right.
In fact, the law was changed several years ago that limited the size of even an agricultural lease to no more than half an acre without legislative approval. And residential leases have always been at least half an acre for properties that had no infrastructure. So in the language of the recent resolution we submitted for changes to the law, not less than half an acre was not language we added to the law. That was already existing language.
I understand.
What we had asked for and what we're trying to do is we recognize that issue of a finite amount of land, but a potentially infinite number of applicants, and the need to reduce the size of those lots to even a horizontal property regime. So, we're looking at trying to do that, but the only way you can is to have the necessary infrastructure, specifically sewer, to be able to reduce the lot sizes to a much smaller subdivision lot like you see in subdivisions with sewer capability.
Right. And which really leads to my main question, what I'm really trying to get to, right? And really, it was eye-opening to me that there was Chamorro Land Trust on Barrigada Heights property. And of course, we all know the value of Barrigada Heights property and whatnot. So I guess the question is, has a value comparison study been made or thought about how GovGuam and CLT awardees may benefit more if certain tracts of land are privatized and sold at great profit for more revenues to the government, and perhaps to be able to purchase cheaper land in greater quantity. That way there's more land to give out. In other words, you have some very expensive land in your inventory. Has it been thought out to perhaps looking at selling that off in exchange, buying larger tracts at a lower price so that more people can be serviced? Has that been discussed?
No, that has not been discussed at the commission. However, I will say that future planning is necessary for the success and survival of the trust.
Okay. Thank you, Mr. Chair. I know that we only allowed one question, and thank you for the latitude. I'll come back.
Thank you very much, Senator Espaldon. I share the same concern that the Senator brought up about the size of properties that have been issued. For example, the law has provided the guideline that for those who are applying for agricultural land for subsistence farming, the limit is between a 1/4 acre to a 1/2 acre. And it was interesting as I was looking through the list of leases that have been issued, in fact, as recent as 2017 up in the Barrigada Heights area, there was one individual who was a 1995 applicant, but I guess, held out until he got the location that he wanted. And I was able to get 2 acres of agricultural land. And then as I went through, as I was looking through that, there seems to be quite a number of those leases where what was issued was certainly a lot larger than what the law allowed for. And that is, that I find concerning. The other piece that I was very concerned with about the information that was provided, and it, I certainly appreciate all the details that the Commission has gone through insofar as even being able to track how the switches were made from who, when, and all that stuff, was that there was a number of leases that were issued, and on that one data column, we did not have the information of who was the approving official. And, I would think that it was either, I guess at a time, it was either the director or most recently now it would be the Commission. But I found that rather disturbing that we did not even have on record the name of the approving official for the transfer. And I think that was on the list that contained the switches of numbers or leases. So might there be any explanation as to why there were numerous cases where you did not have, that information was not available?
I'm sorry, you received a list on the transferred and switch list that doesn't say who the approving official is?
That's right. The hold on a second, I'll find it here. Okay, I'm going to go ahead and yield to the next senator while I look for that. Senator Uggan?
Sorry, if I may respond, I
Sure.
think I know which lease you're looking at where a larger lot was issued, did you say 2017, to an individual at Barragata Heights. When we looked into, we did a thorough review of the leases at Barragata Heights. And when we looked into, I saw that lease as well and questioned it. When we looked into it, that individual's lease was issued years ago and had been waiting for signature or execution, and only in a recent year was it finally, I guess, signed or entered into the system. So it had been a pre-existing lease prior to this administration where that land was given out at that time.
But still, the size of the area issued was larger than what the law allowed for, unless he was a commercial farmer, which I know he isn't.
But there are a number of large agricultural leases in the Lot 5382 area of Barragata Heights, and that have gone back a number of years. And they've been back there. In fact, some of them have already died. But there are a number of those larger lot size leases back there.
Okay.
And they date way back.
All right. Speaker?
I guess if I could just follow up on my colleague's question earlier. So you're proposing to ratify all of these leases that go way back, but he was questioning about the recent ones. I guess, see, we had believed, because we were seeing the clearing in Barragata Heights recently, that those were recent leases. And I guess you're saying now that many of those are not recent leases, they're old leases that they just haven't been able to access until the road started to get cleared. Are there any recent leases then that we could treat differently? Like recent leases where they haven't put up anything yet, or just things like that?
Right. Understood. And I think this, like you said, it goes in line with Senator San Agustin's question. Why are we not treating Barragata Heights any differently than the rest of our leases? Again, it came down to the Commission's finding that the leasing at Barragata Heights that has occurred over many years was similar in nature to leasing that happened around the area, around the island. So the Commission did not believe it to be fair to choose a specific geographical area where we're going to take back what's been done, right? And that's what we would be doing at Barragata Heights, penalizing those at Barragata Heights for our errors. We also considered, okay, if we don't want to cherry pick a geographical area, do we want to say all the leases that have been given out in the last 2 years, 3 years? What are we going to do with those? And again, it came down to the Commission realizing that the internal policies that were followed by the trust for the last several years were applied across the board. And so to cherry pick any of those, the Commission decided that it could not do that.
Are there any leases in the last 3 years that fall into this category of skipping other people? Because you make it sound like this is a problem that occurred way in the past, and so I want to know what happened in the last 3 years. Could you just tell us what's gone on? I know that the board has not approved leases in the last 3 years, so that issue remains. But what about this skipping? Did that occur in the last 3 years?
So the issue has always been, and it was definitely enlightened in 2009 when they were trying to find the people that they couldn't find by posting a list. And even though they were able to publish a really large listing, they didn't go the next step, which was to purge them from that list. And so we're still having to play with those same individuals who are not able to be contacted. So it became a very difficult process to continually find people. We were trying to find different ways to try and make the program work as efficient as we could to get leases out within that group of people from December 1995. And we then looked at all of December 1995 as just a group, as opposed to continually going down the line and constantly moving past the person. And so as long as, and you know, the intent, I think if you look at the first come, first serve, and you take it to its specific letter, you know, if you skip a person, you've just violated, and that's what we found. If it wasn't for the very first 2 people on the list, everybody beyond them was skipped. And so until we were able to purge that list, and that's part of the recommendations we're asking for, is the ability to do it within a reasonable financial prospect, rather than, you know, paying a lot of money for a publication and then ultimately paying even more money just for the registered mail mailings. We don't want to violate the intent of it, and we want to continue to go first come, first serve. But if you get a chance to look through the resolution that we submitted, we have processes involved in there so that we can continue the intent of first come, first serve, and weed out those that we just can't find. We're going to give them every possible way and avenue to be notified that we can think of, but beyond that, we need to purge them off the list. So we were looking at all of December 1995 as a group to be able to find people to get them into leases.
Okay, let me, thank you. Let me ask you this then. We've heard people come in here, even Senator San Agustin, saying, I'm on that list, I've never been called. And I think we had testimony the other time we were here that they say that. Are you able to tell us that these people haven't been called because you just haven't got down that far on the 1995 list? Is that what we're saying? So when we say we're skipping uncontactable people. Are you confident about that? Or have we skipped kind of randomly on the 1995 list?
No, in fact, I think in one of the lists that we did provide you, you will see that there are 1995 applicants who we didn't skip but had not ever been issued a lease because they were contacted, they were given notices of an intent to award, they were asked to do a survey, they never concluded the activities that were necessary to fulfill a lease. It could have even been, we need the supporting documents, like birth certificate, for example. Mm-hmm. They didn't fulfill the remaining requirements for us to take that last step of issuing out the lease. And there's a lot of them in there and we can go over that with you individually if you like, but there was a big attempt to go talk to all these people, and they just never came back. And if they came back, and many have come back after the fact and go, hey, look, I finally did it all. Mm-hmm. Is that land still there? In some cases, they might not have been because, prior to the COTC moving in with land management, it was a very difficult process as a standalone agency that didn't have a lot of the land records requirements that they have to have today to be able to see and know what was given and what was not given and what is available and what is not available. But there were a number of people who were given the opportunity, but then again, there's a lot of people that are just not been able to be contacted for one reason or another. Telephone numbers are not working. We have multiple boxes of return envelopes, or actually we even put them in their folder when we send them a mailing to ask them to call us, and there's no response. The letter comes back. You know, what more do we need to do? But publicizing the names, posting them on the website, putting them in the mayor's offices, and doing it for a specific period of time, trying to get people to come in, and not doing it as a major group, but doing it as just groups of people that we want to work with at a time.
All right. I understand, and the lists, you're right, they show that type of effort, but I guess I'm just still perplexed then. Why do people come in and say they've just never been contacted, and it sounds like they don't think they've changed their address or anything, but so I feel like there's a little bit of a gap there. I also want to ask, okay, so in the last 3 years, how does somebody get one lease in Barragata in 2017, yet some of the leases in Barragata, same lot, were from years ago? I thought that the commission was finding tracts of land that could be used for residential leases and then going down the list and, taking care of every piece in that lot or that tract, whatever, and that after it's divided up, right? But now that's why Barragata Heights sounds so, I don't know, suspicious, but it's hard to understand.
It's
How did
not
some people get
suspicious.
their lots long ago, some are getting them recently, and yet when we ask you, where is the next, subdivision for Chamorro Land Trust going to happen, I thought you're able to point out a piece. This is the one we're looking at. We're going to subdivide this, and then we'll be able to get this many more leases, right? So that's
exactly what happened here. So those ones that have been there for a number of years, again, all of Barragata Heights was originally known as a basic lot of 5382. And on the south side, or on the side facing east, is where some of the original lots were first issued. And so the part that's gotten a lot of attention is the part on the west, the parts that are the side of the hill that looks down towards Harmon. I'm just looking at the list right now. The result of it becoming available was because we did those master plans where we had we identified where all the properties could be. We broke down this big tract of land and said, here is what the lot sizes should look like, and now we have lot numbers. Now here is an available piece of property. Let's go out and find people. And I'm looking at our list for Barragata Heights, and the first 35 of them were from December 2nd, 1995. And I think that might have been I don't know what day it was, but then we have a big group of December 4th right after that. So, there is a predominant number of folks that were from the early part of the list. And if I go all the way down to number 80, that's still, within that first week, December 9th. And then beyond that, for the next 20, there are a variety of different dates, but most of them still in December. But the ones that are not in December 95 are individuals who have now taken over someone else's lease because of a death, some of the older folks that were there originally. And that's when you look at even this, you'll see some of the huge properties that were issued out in, a long time ago. I'm looking at one right now for 5 acres.
Yeah, let's talk about the issue date. So the issue date for Barragata Heights properties, do they vary? I don't have that list in front of me, but did they all come out, when they were going down the list in 1997? Or were those issued when were they issued? That's what I'm asking about. It sounds like they've been issued randomly, some way back then and then some just very recently in 2017. She explained one in 2017, and it sounds like a reissue date or something like that. But
no, so the older ones, like I said, all the way back from the late 90s, 98, I'm looking at, in the early 2000s on the issue date.
Okay.
Those were the side of the hill, on the east side of the hill. That's when a lot of those lots were first leased, the signing dates of those leases.
And what about the other side of the hill? Or when was which is the lot that you're talking about, lot 52?
Well, 5382 is the entire hill.
Okay, so the
All
entire
of
hill. So
Barragán Heights.
that's what my question is. Why wasn't that entire hill, distributed at the same time?
Because there was no plan. I mean, even the
After the
part-
plan, after
even-
you came
well,
up with a plan and you started to issue even one lease, why weren't they all issued?
we did.
Okay, so that's
We
what,
did
that's,
after but prior to there being any kind of master plan, the side of the hill when they got issued leases, if I can read it out, they were given out a portion of this lot, a portion of not more than 1 acre,
Yes.
a portion of that. So, when you have these portions, it just means they know that you got 5382 and it's going to be right over here in
Right.
about this
It's not
area.
exact.
I don't have, there's no map that says where it's going to be except for maybe some kind of a drawing.
okay, so you're telling me that it's your findings that Barragán Heights was pretty much all distributed by 2002?
No, not by 2002.
Oh,
No,
Then-
no, that side of the hill, there was a good part of it that was distributed out on the east side of the hill.
well, why not
But-
the rest? That's,
Because there was no master plan of it. Nobody knew what lot sizes there were. There was no design. It was just, well, we know we got that side that's available. We're going to give you, an acre portion, half acre portion, and that's all it was. There was no legally defined location at the time when it was done. And it wasn't until 2015 when we started making subdivisions. And
Okay,
we just finally designed, we first had to go back and find those people who didn't even have a map yet for those portions of.
all right, so let me
Locate them.
rephrase this question then. So in 2015, when you had your subdivision, who got lots? Was it people who had leases since 2002? Or did any of those,
No, the individuals who already had existing leases that
Prior-
described their property as a portion of, we now knew what their lot
yeah,
number
so you
would be
put them
called.
down on lots
We
in
went
2015?
back, we found them.
Who else got lots in 2015?
There weren't very many that were done at the time. Most of them were done starting in 2016, probably.
Okay.
Right, well, the map had already been in existence since 2015.
But were all the, okay.
So when the map was drawn, then the department could start assigning the lots. And then so that you could have a legal description on the leases. And I think it was 2000, that's where you're seeing the leases that are more recent, for the most recent map that was drawn.
Senator?
Thank you, Mr. Chairman. I noticed that whenever you appear before the legislature, your legal counsel was not with you. And the reason why I bring that up is because in May, when all these issues surfaced, or even prior to that timeline, there were some concerns about questionable land leases being dispersed, whether it's staff members giving land leases to family members, staff members giving land leases to fellow coworkers, and those were questions that were raised, legitimate legal questions that were raised. And one of the policies that you implemented as a commission, because I was at that commission hearing, was that one of the actions that you undertook was that you were going to have training on ethical guidelines for your personnel. And I look at this proposal that you're presenting to the legislature with your resolution. And I understand we're dealing with this, Mr. Chairman, this legislation, and I will get to that very soon. But there's absolutely no mention of amendments to the law that would address those concerns. And I bring that up because in May, I had introduced a piece of legislation 284-34, which would have required these things to be in place. It would have required rules and regulations which shall include express provisions for dealing with standards of conduct, conflicts of interest, disclosure, self-dealing, honesty, and ethics. And it also the rules and regulations shall also include whistleblower protection for employees who report nonfeasance, misfeasance, or malfeasance in the administration of the program. And those are critical aspects of personnel responsibilities, making sure that these rules and regulations are in place so that personnel may no longer be questioned. Hopefully, well, if they follow the rules and regs, then they will no longer be questioned about their actions and their decisions, because there will be rules and regs that will provide guidance and counsel. So I'm looking at your proposal, and it really does not mention anything to that effect. And I find it very unfortunate, because you've been trying to address these issues, but then at the heart of these issues are the personnel who have to implement the program on behalf of the applicants. The one statement I want to make, Mr. Chairman, is, and I think that the way the legislation and the request from the Commission, the way it was presented, is for the legislature to ratify the decision of the Commission. And the way I was made to understand a trust, it's not viewed as another government of Guam agency. This Chamorro Land Trust is supposed to be quasi-independent of the government of Guam. And Mrs. Santos knows that, because her son, Uncle Angel, fought vehemently to make sure that this is implemented. It's supposed to be a trust, self-sustaining, and you're able to assist our Chamorros based on the definition of the law with giving them properties. But the way the request was forwarded to the legislature is that you want us, the legislature, to act on and ratify the decision, approve the decision that you made, rather than presenting to this body. And that's why I brought up the issue about legal counsel, that if in fact at the heart of understanding what a trust program is and the quasi-independence from government of Guam entities, that the proposal that should have come to this legislature is, we have some of these land leases that have to be approved by the commissioners, by law, but we need legal authority. So for the 2,877 leases that were identified as possibly voidable, that's what the legislation should have read. Have language that says the voidable leases, based on the language, it would set parameters of how those voidable leases would be approved, and then the authority will be given to the commission so that you can be able to approve those. And then on the leases that are with the now and void status, even that brings into question, because already the AG opined that it's now and void. It has absolutely no validity, regardless as to what the explanation is and how we want to be sympathetic to individuals. The decision and the action of members, staff of the Chamorro Land Trust led to the point where it did not comply with law. So even with that, if the intent of the commission members was to ensure that you're given that authority, it all goes back to that independence that the trust should have in administering the leases of these properties and making sure that the program maintains its integrity and also is carried out as efficiently as possible. But then that proposal should have read something to the effect that would give the authorization to the commission to be able to take action on some of those now and void. But right now, what I see before us, Mr. Chairman and members of the committee, is that a request based on the proposal that was forwarded by the Chamorro Land Trust is saying, ratify our decision. 2,877 leases, approve it. And then 102 leases that were now void, approve it. We don't even know what you saw in terms of moving forward and saying, okay, these are the certain circumstances, these are valid according to law, but the AG said we need to act on it as a commission, so that's what we did. Now we're bringing it, we're asking for the authority to be able to make sure that we were legally within bounds. And that's where the legal counsel is very, very critical. And I encourage the commission members, anytime that you're dealing with your activities, not only the meetings, but coming to this body, because rightfully so, that legal counsel should be able to respond to some of these questions. Because that would be one direct question I would ask. Do you understand the nature of a trust? And if the legal counsel says, well, it's a government agency, then to me, that legal counsel had no business assisting and guiding you legally. Because this trust is on behalf of the Chamorros as defined in the law, and the trust should act as much as possible away from the government so that you can effectively carry out this program. And that's, Mr. Chairman, I hope that you would consider taking that approach rather than a carte blanche ratification of the decision of the commission, and give that decision rightfully to the commission to make that decision based on parameters that will be adopted by this body, because that's what this body's responsibility is, to set those policies, set those parameters, and make sure that in fact it only helps to get the program off the ground and restores integrity as well as transparency with the process. But I close with that because I think that it's very important that we get back to understanding exactly what a trust program should be. Based on my understanding, and I believe that there's a number of attorneys out there that have also reinforced my understanding of how the trust should run, not where the legislature steps in every now and then and makes amendments. No, it should contain the necessary policies and parameters so that the trust can run quasi-independently of this body as well as the front office. Thank you, Mr. Chair.
Thank you, Senator. Senator Torres.
Thank you, Chairwoman Verheeren and members of the Commission. I want to thank you for your diligence. It was very informative to read through your resolutions, and I certainly appreciate, since the oversight hearings that were held in May, the methodical way that you went about documenting the thought processes, your review processes, and some of your conclusions and thoughts about how to remedy the issues that you ran across. But I was also very curious about the nature of the bill and, why we would arrive at having to come through this piece of legislation, because as the prior speaker, Senator Uggan, was discussing, the trust has full authority. And I think you also acknowledged in your resolution 2018-10 the authority of the Commission to ratify those leases, the 2,877 leases. And so in that very act, given what Title 21 GCA and the Senator Paul Berdallo rules and regulations set out, it seems like the act of the Commission and the decisions that are made with regard to issuing the leases should stand, right? You have the full reign and independence to do that. And the rules, as I in my quick review, don't require legislative ratification or overview of the actions of the Commission. That's correct, right?
That's correct. And
okay.
If I may, 2018-08, I think that was the resolution that ratified the 2,877 leases. So the Commission moved and ratified those 2,877 leases. However, upon advisement from our legal counsel at that meeting, he advised that we, further bolster our ratification and request for the legislature's validation and approval.
See, that's the part.
Which is why we...
Yeah, that's the part that I don't understand. I don't understand why, with the authority given in 21 GCA Chapter 75, why it is necessary for the legislature to validate through an enactment into law of the leases. Because what I worry about, my initial impression is parties and applicants to the Chamorro Land Trust, by doing this, then they have no recourse if they wanted to challenge the leases in any way or have any challenge to the commission, and that's my concern, is I don't believe we have a place in this right now, and it seems like an overarching effort to once and for all cement those leases so that they really have nobody has any recourse. No one can challenge them. No other person who feels that they've been wronged or overlooked or cheated out of the system has no recourse with regard to those leases. And that's what concerns me, is the absolute nature of that. But insofar as the 102 leases, in your resolution you mentioned that you have full extent, to the extent of your authority per the law, you can ratify those voidable leases, which you did. But the 102 you acknowledge in your resolution, you don't have that authority to ratify those that were derived from a switched application date and time. Now, is the intent of the request to the legislature to have us put those leases in place, or are we simply just, so are you acknowledging that those leases exist and we're just confirming that they exist, notwithstanding the fact that the AG categorized them as null and void? I'm trying to understand where we are in the situation. Are we creating these leases by act of law, by saying these leases now retroactive to that date are valid? Or are we simply saying through this legislation we are validating that what you did is okay, notwithstanding the fact that the AG opined that they're null and void? Am I clear? I'm just trying to understand what exactly we're doing.
It would be the latter, the first.
So the latter would...
Former.
The former. So where the AG opined that these leases are null and void because there was no authority per the rules and regs to jump the line, I'm sorry, I don't want to switch places, dates and times. So essentially those leases don't have standing. And by enacting them into law, we now establish that they have standing, and they're retroactive to whenever they were enacted, correct?
Correct.
That's a lot to ask. And so, and then I see later there's another proposal to change the rules and regs so that this type of practice can be allowed or permitted going forward, right? Prospectively? Okay. So we're correcting a wrong by putting them in place, and then the plan is for you to prospectively allow for these things to happen. Is that right?
Correct.
Okay. Yeah, I'm just trying to clarify my impressions, and I appreciate. But I mostly appreciate that you laid it out in the way that you did, so that we could at least give you the full. I can give you the full benefit of understanding what it is that you're trying to accomplish.
Thank you, Senator. Senator Spadon.
Thank you, Mr. Chairman. Mr. Chairman, I'm going to pass on this round, and I wouldn't mind having it come back to me. Thank you.
Okay. I don't have, well, I do have one question on the, I know that one of the issues that was certainly raised in the oversight hearing was the idea that, staff were getting relatives basically favoring their leases and whatnot. And I just noticed that in the list that was provided on the transferred and switched list, the column was provided to the question of the relationship between the approving official and the transferring parties. And in all cases, it was put as unknown. I think that was one of the data elements that the commission had requested to be done. So is it the case that I mean, basically this tells me that there was no relationship between, in any of these cases, between the approving official, not staff, but the approving official and the transferring parties.
It was based on whatever documentation we had on file to tell us if there was anything like that. There was never any requirement at the time to document anything like that. So, you know, if we were to go back to, you know, individuals who are no longer with the Chamorro Land Trust Commission or have also passed away, there would not be any way to find out that. But it was based strictly on whatever documentation was on file that would state any information like that. Today, the department's policy is to declare any relationship to anybody, not just within Chamorro Land Trust, but for any other activities that may be requested of the department, to the 3rd degree of consanguinity and to the wife's 1st degree of consanguinity. So that's the department's policy now for having anything like that. So you would make that declaration, it will go in the file so that it's for the record that whoever the individual was that recused themselves because of a relationship, but it would go to the 3rd degree of consanguinity and the wife's 1st degree.
Okay.
Or
Anybody
spouses
else?
or whoever.
Senator Spaldon?
Thank you, Mr. Chairman. Within the requirements of the rules and regs or the law, I'm not sure which it is, I believe that once a lease is awarded to an applicant, then they have 1 year to, I guess, make use of the land, right? Whether it's to build a residence or to farm it or whatever. And out of these 2,800 some leases that you're asking us to ratify, has there been a check on, at least a good sample check, to see what percentage of those who have been issued leases have actually, in the past, you know, whether it was recent past or in the past, within the past 20 years, what the percentage is of those who have not met that requirement? Because I would imagine that if they have not met that requirement, then the argument is going to be that, or can be made, that they should then give up their leases since they're not doing anything with the land. And maybe then you can award those pieces of property to those who are still waiting. So has there been any kind of a check to find out, you know?
No, we have not tabulated to find out how many are occupying, and what is that with, and if they're vacant, are they still within the allowable time frame? I think this kind of goes back to your last question about compliance, because that is a compliance issue. And when the commission moved to ratify these leases, we all ratified with the clear understanding that ratification did not make any judgment on compliance. It is just making the lease in the file whole because it now has commission approval. So looking at whether they've complied with the lease terms is still within the authority of the commission to go and do, and if necessary, void a lease. But that was not...
As opposed to trying to avoid, to identify those lots that are not being used whatsoever?
Well, in our resolution that we submitted with all the spreadsheets, you'll see in all the 1995 original lessees, and I think we did it on all of them, we have a column there whether or not they occupy or not, yes or no, and if there's a structure. And most of that was not done from actual site visits. Certain ones of them were all site visits, but most of these were done by aerial. Look at aerial overlays to determine whether or not some activity has occurred on that property. There are a number of items written in the current rules and regs and in the current law that, if fully enforced, most of our people would be without a lease today. But the problem with the issue of have they done anything within the first year, it may not even be to their, it's difficult for them to even do anything when they completely lack even the road to get to that property, let alone the water and power. And so for them to be able to try and do something, it is extremely difficult or near impossible, because they don't even have the funding to be able to get into the land to put up the infrastructure themselves. And so to hold that to them and tell them to move on, it just puts us in a quandary. They can easily come back because the law allows them to decline that municipality, where they'll say, well, then I decline this, give me another one that has something so I can use it within a year. And that something doesn't exist either. So that's the issues that we have. And many, kudos to the chairman, because there's been a lot of attempt to make sure that the Survey and Infrastructure Fund gets monies necessary so we can at least go do those basics of getting, the easements opened up. I mean, that was all part of even the whole idea of doing the master plan, so we can even identify the easements for the utility companies to be able to go in and put their poles if they're going to decide to do something. They won't put a pole, GPA won't put a pole up unless they are absolutely sure that it's on a right-of-way easement. But yes, we have looked at a lot of these properties. Most specifically, we visited a number of them. But a lot of times, because of the number of people that we have and the ability to do, all these properties, we're highly limited. And so a lot of times we get tips from residents, from whoever, that tells us there's an issue going on. Sometimes it's a news article of a drug bust somewhere that tells us whether or not a lessee may have been involved. And those would be conditions for termination. But again, if there are people living there, then we're looking at having to displace people.
All right. I understand. I guess what we need to reconcile, I guess I'll speak for myself, is that yes, we understand there have been some missteps, oversteps, and whatnot by past practices. And again, a lot of it probably doesn't fall upon this commission as it sits right now. It's just kind of one misstep over another, and it creates a bigger problem. The issue before us really is whether we're going to agree to ratify what you believe is the proper solution on all the leases that have been let out. Some were let out properly, and some weren't. And I guess folded into that is trying to understand, and that's why I do appreciate your resolution that makes recommendations of what needs to be changed, although even that, I'm looking at some of these, I have some issues and concerns about that. But it's a tough one. It really is, only because there are others who have been waiting a long time as well. And yes, it's we can say, well, going forward, we'll correct everything, right? We'll bring it to par, and that's a possible solution. But again, until we examine some of even the injustices that was created by the management of Chamorro Land Trust, right? And then you put it side by side whether those who have been granted leases are really even using it for what the intent of the Chamorro Land Trust was established for, right? Without doing that, it's almost hard, at least for me, right, to kind of blanket ratify everything. Because there may be some good pieces of property in there, and like I said, and I can name out a few, and I won't do it here in public, right? A few pieces of property and a few people who have been granted land, Chamorro Land Trust, who already have had land, I don't believe met the priority requirement, and on top of it, no longer even live here. So whether they're even using the land for what the intent of the Chamorro Land Trust law was established for all of a sudden defeats that purpose. While all the while, we still have a lot of families waiting. And that's a concern. And I just state that's the debate that's going to have to go on in my mind. I understand the issues you raise. One of the questions then pops up, well, if we don't ratify it, then what happens? What is it? I mean, is there an answer to that? If the legislature does not step in to ratify the actions of the Chamorro Land Trust Commission, where does that leave us?
No, as we had, the resolution number 8 mentions, the commissioners have taken the action to ratify the over 2,877 leases.
Right.
We're just asking that the legislature to concur, validate. If not, that's, they've been ratified.
Which begs the question, is that even within our jurisdiction to do that?
Okay, but the most important one too is the action that the commissioners cannot take, and those are the ones that were labeled as null and void, the 102 leases. And we gave a lot of explanation as to, you know, those individuals and what had happened there. And you can see that, you know, it was something where a family member gave it to another family member. And so it was an issue to try and help another family member. The compassion that was behind it all. And that's what we're asking for from this body as well, is the compassion to understand that families are trying to help each other. And that's what happened in these 102 specific cases. Moving forward, we're looking to have the law changed so that that compassion could continue for whatever reason, that a person wants to transfer their application rights to another qualified individual, especially a child or, you know, some other close relative. But that's the one that's of particular concern. And, you know, we can only ask and request for your assistance in that.
And I guess the answer to my question, or your answer to my question in a roundabout way, is that if we do not ratify, or if we don't pass this bill to ratify your ratification, then these leases are null and void.
No. No. We are only asking you to validate the decision, just to have that one last bit of concrete seal for the ratification that was done on the bulk of the leases. There's two groups, right? The voidables was ratified. The null and voids, there's no authority for the board, according to the AG, to take action on them. So we've identified who the null and voids are, and we've presented to you the details of those null and voids. And so all we're asking is take action on the null and voids to give the authorization so that they can be approved. But, you know, we're also asking that you just concur with our ratification of the greatest bulk of them, the ones considered voidable, which we have already taken the step to say they're ratified.
Okay, so then I think I understand the answer to my question now, and you're saying that whether or not we vote on it, on this bill, you have already ratified it, and it goes on. So it's not necessary for us to even have to entertain this bill.
In reference to the 2,877 voidable, yes. That cannot be applied to the 102 null and void that the commission cannot ratify and has not ratified. The commission is asking for you to ratify those 102 null and void leases.
So,
right, so this is a two-part bill, you're saying.
Yes.
You're asking us to ratify your ratification
Validate.
of the validate
or approve.
The ratification of the voidable leases, the 2,800 some leases, and to also validate your ratification of the 100 and some leases that were void ab initio?
No, almost. The first part is the 2,877 that we've ratified. and we're asking you to, I guess, validate the Commission's ratification per the advice of our legal counsel. The second part is the 102 null and void leases that the Commission has no authority to ratify. We are asking you to ratify those 102 for us.
So one is to validate,
Yes,
and the other one is to ratify.
Yes.
Those are the two actions you're asking this body to do.
yes.
So if I may step in for a minute?
Yes, please.
So if I understand, the reason why the Commission is asking the legislature to validate the ratification action on the 2000 leases is because those leases did not fully comply with the law. The law requires that you go on a first come, first served basis, and that fundamental rule was probably complied with. But then there's the other part that confounds everything, and that is the prioritization, which, is left to interpretation that a guy who applied in that maybe you're never going to exhaust that priority one list, but nonetheless you went ahead and you issued to a 1995 applicant who may have been a priority two while you still had. So there's still that cloud, it seems, over those leases that have been issued. The other part, the 102 leases, you're asking us to basically legitimize the actions of those that were taken on those leases, because there was no authority in the first place to do switches other than, compassion. But the law doesn't, I guess the law simply says you can't do it. And it doesn't say unless this or this or this. And so that part, obviously, the Commission has no authority to legitimize something that was not allowed by law. So that's the way I understand where we are at here. I don't have any other questions. Quite honestly, since I've received the the resolution, I've looked through it. I've been trying to get my arms around it. I don't have any questions, any further questions right now, and so the committee's just going to have to figure out, how to report this thing out. I mean, I think the suggestion made by Senator Uggan about, basically saying, go ahead, you have the authority this one time to legitimize the switches, which are not allowed by law, then, I think that has merit too. But I think the committee still needs to get its arms around it. So if nobody has any further questions, do you have any closing remarks that you like to make? Okay. So with that, then we'll stand in recess. The committee will stand in I have 5:02, and the committee will stand in recess until 6 p.m. when the public will be able to give its comments. Thank you.